Yeah.
No COVID test going in, no COVID test coming out.
Charles Bale.
Where?
No, what I meant
Well, her daughter, I don't think knows. Cindy's got a granddaughter living there because her mother can't cope with anything. Now, I'm sorry, for a few days you could have given that the problem of that. But I don't know. I said to Cindy, do you know what? I said, I really wish I was in London then. Then I wouldn't have this responsibility. It's not my responsibility.
No, it's right. It is a responsibility, yeah.
Anyway,
Let's do 1, 2, 3. You hear that? 1, 2, 1, 2.
No, I can hear.
no, it's absolutely that way. She's like,
1, 2, 3. Check 1, 2.
Go to the other mic.
I thought
1, 2, 1, 2. Check 1, 2.
yes, she'll get it.
Hello, hello, hello.
Let me try different mic.
Any notes? Not one of those little things they use to. I don't know, but
Already?
Yeah. Okay.
I've got the judge.
Oh, I'm doing that.
I've got the judge there.
Yeah.
Yeah.
Well, it's a lot cooler in here now.
Yeah, come through.
The main screen at the back, we don't need that on doing. I've got live streaming on, so we don't need that screen on. Is that correct?
I'm going to go for Sprange.
Thanks, mate. Cheers, bye. Bye-bye.
Very elegantly done.
We couldn't get the
The French or the German.
Yes.
Mine's the easy one, to be honest.
well, it's all these barristers with funny names. We should do something like that.
Yeah.
Okay,
Initial
council ready?
Yeah.
Okay, so if you're not speaking, I request that you politely put your masks on. Any mobile devices to be switched to mute, please.
Are we good to go yet?
Yeah,
Is it?
Appellant.
Very much. Transcribers ready?
Sorry.
No, not quite. Sorry.
Judges
Excuse me,
are
there's no
outside.
glass
I mean,
that's free there.
We won't.
no, I'm sorry.
Enough.
Carry on. Recording.
Cleaner.
How long do you think, transcribers?
5 minutes.
5 minutes?
I think we've got 5 minutes.
All right.
Hold on.
Have we got a problem?
Yeah, it says you can't hear the You can change the cable, don't
I've kept the cable.
Because I can
You
hear
can hear the judges.
the judges.
you? Can't hear, you still can't hear the
I don't know.
microphone.
Will it be resolved in 5 minutes? Otherwise, they will come in.
Testing, testing, 1, 2, 3.
Nothing on it. Must be the lead or something.
I'm getting a signal through.
Can you manage just from the voice, madam?
Try different.
It's much more difficult.
Okay.
And it's also not being recorded, is it?
We're recording it. You want to try different cable? Put it into 5.
Don't know that we can rely much further.
I think it's just that microphone.
You've gone checked it.
Do you want to tuck that one down?
Yeah, I think it's
Yeah, that's better. Well, this can't. The other one is coming from here.
You hear on that one?
Yeah.
We're good to go?
Just 1 second, sorry.
Testing 1, 2, 1, 2.
Yeah.
Yeah.
You hear that?
Yeah.
Great.
Oh,
Okay,
You hear this?
okay, thanks very much.
Can you make sure he turns it down to the
Yeah.
speakerphone? Thank you very much.
Court rise. Motorola Solutions Inc. and another, and Hytera Communications Corporation Limited and others.
Yes, Mr. Bayar.
My
We have
lords,
a
my
lot to
lady,
get through.
I appear with Mr. Milner for the appellants.
Indeed, we know all that. We have
Thank
a lot
you.
to get through.
You do.
We seem to have a huge stack of authorities. I can tell you that we have read the skeletons, we've read the judge's judgment, we have read the witness statements, we have read Berry Trade, Dora, Firster, Finken, and Unilever.
What was the Ocean Trade was the first one, was it?
Berry Trade and Musavi.
Berry Trade, thank you, my lord,
Yeah.
yes.
Berry Trade, Dora, Firster, Finken, and Unilever.
Thank you very much. Then, although your lordships would obviously have read the judgment, can I go straight to that just to make the perhaps obvious point that the judge's admission of the without prejudice material had a decisive impact on the outcome because it was the basis for his finding of a risk of dissipation. Your lordships have that in the judgment at paragraphs 35 and 36.
Yeah.
My lady of that. Where, in particular, having said at the start of 35 that the critical issue is the admissibility of the without prejudice evidence, then in the middle of 36, about 7 lines down, having referred to the evidence about the underlying facts which are the subject of the trial, he says, however, I didn't consider that taken on its own, this conduct would on its own justify the conclusion that there was a real risk of dissipation of assets, bearing in mind other factors in the case, and then he sets out those other factors: substantial multinational company subsidiaries in respectable jurisdictions, Sapura, which is the UK one, is a government contractor. There's been no attempt to dissipate in the many years since proceedings were commenced. So, based on that, he said in short that the argument that the underlying facts generated a risk of dissipation was not one he accepted, but when you put in the critical factor, as he calls it, of what was allegedly said at the settlement meetings in October and November 2019, that was decisive. If we could then go straight to the parts of ocean bulk, which is divided 10, please, of the core bundle. That's the most recent Supreme Court authority. It will all be, sorry, I said 10, but I meant 9. One finds there conveniently set out both the exclusionary rule, the without prejudice rule, and the relevant exception. At the bottom of page 675 of the law report, after having referred to Unilever and the Russian Tompkins case, Lord Clark, giving the judgment of the Supreme Court, said that Lord Justice Robert Walker in Unilever observed that the rule was recognised as being based, at least in part, in public policy. Its other basis or foundation is express or implied agreement of the parties themselves. Communications in the course of their negotiations should not be admissible in evidence if, despite their negotiations, a contested hearing ensues. So, in other words, if there's any contested hearing, then this exclusionary rule applies. At 25, Lord Clark noted that further passages from Unilever show, as he put it in the second line, that the rule is not limited to admissions, but now extends much more widely to the content of discussions such as occurred in this case. And then he cites 2 passages from Unilever, which we will come back to. He concludes at 27 at the foot of the page that the without prejudice rule is thus now very much wider than it was historically. Moreover, its importance has been judicially stressed on many occasions, most recently in the then very recent Supreme Court case of Offenlouet and Bossert. Turning forward to page 678, paragraph 32, there's then a citation from a very well-known paragraph in Unilever where Lord Justice Robert Walker, as he was, set out a list of the exceptions, what he called the most important instances of exceptions where evidence could be admitted, notwithstanding that it was without prejudice negotiations. And just below letter C, you'll see point 4, apart from any included contract or estoppel, one party may be allowed to give evidence of what the other said or wrote without prejudice negotiations if the exclusion of the evidence would act as a cloak for perjury, blackmail, or other, quote, unambiguous impropriety, unquote. But this court has, in Forster and in another case called Fazalizadeh, warned that the exception should be applied only in the clearest cases of abuse of a privileged occasion. It's obviously, therefore, that exception which the judge held was satisfied in the present case, the unambiguous impropriety exception. Going back to the judgment, paragraph 72, please, on page 105 of Bundle. At the end of the, halfway through the paragraph, Mr. Justice Jacobs says that there are, of course, differences between the accounts of the participants, but for reasons already given, I am not in a position now to decide as to the competing versions of events. And on the, page 103, paragraph 65, second line, the judge said, I will not therefore seek to resolve such disputes as exist as to what was said at the meeting. And he
says there he's following the approach taken in
Yes.
Dora, i.e. if the allegation is true, even though it's disputed, would it amount to unambiguous impropriety?
That's right. And obviously I'm coming on to Dora, what it says and doesn't say and what its status is or may be today. But it's worth leaving aside the process by which he got there. The approach that he took was simply to decline, expressly to decline, to reach any sort of finding at all. He simply said, as my lord has observed, if what Motorola said was true, then in his view this was a case of unambiguous impropriety. He didn't seek to make any evidential finding other than that there was a good arguable case, aka a plausible evidential basis.
Well, that's not quite the Dora test, is it?
No, it's not the Dora test. And in fact, I've got some specific submissions on this. I'm deeply conscious of the time. I should have told you that Mr. Strange and I had a helpful conversation yesterday. We agreed that I will try and finish by 1:45.
Right.
He will try and finish by 4. That will give me time for a reply, and we can all go away for the last few hours before we're locked down again. So on that basis, I'll press on. Just for my lords and my ladies, note the essence of the factual disputes is summarised by the judge at paragraph 40. I know you've read that, so I won't take you to it. And paragraph 40 sets out what Hytera said in response to what Motorola said, which in turn the judge summarises at paragraph 38. This judgment quoting from an affidavit of a Mr. Nia Wiara, who was the deponent for the Motorola side. And the basis then on which the judge nonetheless admitted what was undoubtedly evidence coming from without prejudice meetings was this, first of all, as to the evidential threshold. He simply asked himself, as I was submitting a moment ago, was there a good arguable case that the content of the meeting was as alleged by Motorola? And one sees that expression and its synonym at paragraphs 63 to 64 of the judgment. And we say in response that as the judge himself acknowledged, the facts were credibly disputed, and we say that the consequence of that was that the evidence therefore should not have been admitted. and that the test of unambiguous impropriety properly understood was not met.
Is that simply because the facts were disputed, or are you proposing some other test that the judge ought to have applied?
It's not simply because the facts are disputed, but as was said in the analogous case of Kuwait Airways, if there is a dispute, then it's going to be very difficult to find a prima facie case. And so the test that I'm submitting, as I will develop in a moment, is that the court should have been able to conclude on the material before it that the relevant words clearly had been spoken, and that, in a nutshell, the unambiguity test applies both to the evidential aspect of the court's assessment and to the other aspect, which the judge also considered, which I'll call the qualitative assessment, in other words, the assessment of the level of impropriety of the behaviour that was said to have occurred. And the judge held that the threat that Motorola alleged had been made, assuming it to be made, was of sufficient impropriety to meet the threshold. And we say that the judge elided, with respect to him, two things. One is a threat to remove assets. The other is a threat to do so by improper means, that's to say, by means which are independently improper. And we say, in the absence of such improper means, the alleged threat, even if it were assumed to be made or that the evidential threshold were reached, was not of the level of iniquity required to break the protective seal of without prejudice privilege.
Are we concerned with improper means as opposed to improper purpose?
Well, there was some discussion in the judgment of whether means were improper, but on a final analysis we say not on the facts of this case, even as analysed by Mr. Justice Jacobs. But where I submit the judge went wrong was in running together the improper purpose and the improper means, and treating the purpose as, in effect, superseding the consideration of the means. In my submission, if you don't have improper means, then the purpose, and let's not, with respect, I don't accept that it's an improper purpose. The purpose of frustrating a judgment, making it harder by moving assets, isn't a purpose which on its own qualifies for the unambiguous impropriety exception. So that's the issue which this court has to deal with. We do say that also, if one stands back and looks at the matter in the round, that the judge's approach overall does amount to a serious erosion of without prejudice protection. As standing back, one has here a factual account given of a confidential settlement meeting, which factual account was not even held to have a greater than 50% chance of success. The judge simply said there's an arguable case. And what was alleged was a threat to do things which were not even unlawful. That's to say, to move assets, not unlawful in itself. That was admitted in evidence, and we say that goes quite a long way into the zone that the courts have often warned about, of encroaching too much into without prejudice discussions. Those are, in the barest nutshell, the first two grounds. The third ground, for which my Lord Justice Mayles gave permission, I think in August of this year, is quite separate, and that relates to the Chabra order, which was made against a company called Project Shortway Limited. And Project Shortway Limited, not a judgment defendant, it wasn't a defendant in the Illinois proceedings, but it is, leaving aside a much smaller subsidiary, it is the top subsidiary in the UK. It's an intermediate holding company, which is at the top of the chain in the UK. I'll take you in due course to the corporate structure chart. What happened here was that at the hearing on the 9th of April, where he helpfully gave his decision following argument on the 7th of April this year, Mr. Justice Jacobs said he wasn't going to grant a Chabra order. One can see that at tab 8 of the core bundle. An order was then drawn up, which is on the 14th of April in the supplemental bundle. He then produced his reasons for decision on the 24th of April, obviously handed down in draft a couple of days earlier in the normal way. There he took a rather different furrow and said that he would be prepared to grant an order unless he could be satisfied that the existing order could be redrafted to extend the protection. And as a result, he did indeed then grant at the consequentials hearing a Chabra order against Project Shortway Limited. And the argument on this aspect of the case essentially falls into two halves. The first half is if the first two grounds don't find favour with the court. So there's a freestanding challenge that we make to the Chabra order. In a nutshell, we say that it wasn't exceptional and the judge didn't find that it was exceptional such as to make it a proper case for exercise of that jurisdiction. The other half of this ground is if the without prejudice appeal succeeds, but Mr. Sprange succeeds on his respondent's notice. The gist of the respondent's notice being to say, well, that this court can intervene and overturn the judge's finding that the non-without prejudice evidence was sufficient anyway to establish a risk of dissipation. And Mr. Sprange says, if you look at the underlying facts of the case, that's enough to infer a risk of dissipation, contrary to what Mr. Justice Jacobs expressly reasoned at paragraph 36. And in that event, then there is a further consideration to be given to whether the Chabra order could be maintained. That's ground 3. I'm going to go straight then into the question of the evidential test, which is a point that my Lord Justice Lewison raised by reference to Dora and Simper. As it were, the question posed by the way in which the judge dealt with it is in effect this: why is the evidential test not the same as any other issue on an application for a freezing order, namely a good arguable case? I should say any other issue, the general test, generally applicable. And to that, we make answers under 5 headings. Number 1, we say it's contrary to the weight of authority on the application of the unambiguous impropriety exception. Number 2, we say in principle it's wrong because disputed evidence, if it's credibly disputed, fails the acknowledged test of unambiguity. Thirdly, we say that it's inconsistent with the settled legal policy of avoiding erosion of the without prejudice privilege. Fourthly, we say it's wrong to admit evidence on a provisional basis because that is contrary to normal principle. It's inconsistent with the analogous case.
Sorry, just pause a moment. When you say a provisional basis, when will this provisional admission of the evidence be revisited?
Indeed, that's the third of my points, that although a good arguable case under this subheading, although a good arguable case is by its very nature a provisional basis of assessment, that the court says the court doesn't have to make a finding because there will be a day of reckoning at a later stage where a final decision will be reached. In this case, that's not going to happen. So it was especially inappropriate to apply a standard which has been developed to deal with interim applications pending a trial, which will come to a final decision on disputed evidence. In this case, there isn't going to be ever any further consideration of the merits.
Good arguable case is sometimes a test used when that is the position. There's never going to be a final decision, for example, in a jurisdictional context. But you say that's not the appropriate course here.
I do say that's not the appropriate course case. I mean, of course, one has to have the better of the argument, is the phrase that's often used in a jurisdictional context. Another context that comes to mind is when in an interim injunction case, it's obvious that the interim injunction is in practice going to resolve the dispute, and there's a whole line of cases. Kane against Global comes to mind, quite an old case now, but where the courts have said that the American cyanamide approach isn't appropriate and that one needs to, without there being a firm rule, but one needs to look at the merits of the case because it's inappropriate to apply standards simply of arguability where there's never going to be a final hearing. But the points I was making under this heading is that say that so far as concerns the issue of admissibility of evidence, which is what we're dealing with, we say that does fall into a category where normal principle is that the court should resolve at the stage when the evidence is being admitted whether it is admissible. And that there's a sort of circularity in deferring that. And we say that there's an inconsistency as well with the analogy of the loss of legal professional privilege in cases where legal professional privilege is said to be abused. So the fraud exception, as it's called, Cox and Railton, where someone says legal advice has been taken in order to further the commission of a fraud. And the approach that the court takes there is to look at whether there is a prima facie case, or in some cases even a strong prima facie case, that the privilege has been abused, not merely a good arguable case or a plausible basis. So that's the fourth heading, and then the fifth heading, I submit that Dora and Simper isn't authority for either of the propositions that the judge seems to have relied on it for, namely that on the evidential side, the appropriate standard was that of a good arguable case, and that on what I've called the qualitative assessment, that a threat to remove assets on its own was one of sufficient impropriety. We say Dora and Simper does not stand for either of those propositions. Can I then go straight into the first of my two headings, first two rather of my 5 headings, which I'm going to take together. So that's what I submit is the weight of authority on the application of the unambiguous impropriety exception in the context of a factual assessment, and my submission that in principle, where you have credibly disputed evidence, then the facts don't meet the test of unambiguous impropriety. And I wanted to start with tab 4 of the authorities, please, the core bundle, which is the decision that I mentioned a moment ago, Alizadeh against Nickbin. I think that wasn't in the list, unless I misheard you, my lord, that you said you'd read 4.
As it happens, I personally have read it, but I just wanted to, put forward the bare minimum that we had all read. I'm sure my lords and my lady have read it too. But,
I'm grateful. It was, as you can see from the first page of the Lexis transcript, it was an interlocutory appeal, and there was in effect, a preliminary ruling and application as to whether evidence of without prejudice negotiations was or was not to be admissible at the forthcoming trial. This case was as far as I'm aware, the first decision of this court after the Forster and Friedland case, which was the case where Lord Justice Hoffman had coined the phrase unambiguous impropriety. And what had happened here was that there'd been a series of meetings, and they were between the parties, and those meetings were tape recorded. And one can see at the top of page 2 the questions posed by Lord Justice Simon Brown. First, were the tape recorded questions properly to be regarded as without prejudice, and second, if so, did they nevertheless fall into an exception to the general rule, but on the ground, next line, that they disclose fraud or other such impropriety on the plaintiff's part. And third, were those questions properly to be decided by the judge hearing the interlocutory application, or as the master had left them for decision by the trial judge. And Lord Justice Simon Brown said that, next line, Dr. Nickbin has not, however, to my mind, wisely sought to reopen the third question. It must be in the interest of both sides to know where they stand. If we go to page 4 of the transcript, the second full paragraph on the page, beginning finally, Lord Justice Simon Brown said, before coming to the disputed tape conversations, disputed, that is, as to their admissibility, their authenticity and content are, for present purposes at least and without prejudice to the position to be taken at trial, accepted by the plaintiff. So that's a case where, just as a matter of fact, what words had been spoken was not an issue because there had been a tape recording, obviously unknown to one of the parties. And then Lord Justice Simon Brown sets out some quotations from the authorities. At the top of page 6, he says, having considered these 3 transcribed conversations at length, not merely by reference to their own language, but also in the light of evidence generally before us, he's got no doubt that the plaintiff here was, upon each of these 3 occasions, genuinely seeking to negotiate a resolution of the parties' difference. And then about halfway down the page, he says, I turn therefore to the crucial question whether these particular conversations ought nevertheless to lose the protection of the rule because they disclose misconduct of a kind sufficient to displace it. And he says that the correct approach is that in Forster, and he sets out the key passage from Lord Justice Hoffman's judgment in the Forster case, which I'm sure my lords have seen. These are clear cases. The value of the without prejudice rule will be seriously impaired if its protection could be removed from anything less than unambiguous impropriety, and the purpose of the rule is to encourage free expression. Quite wrong for tape recorded words to be picked over, as Lord Justice Hoffman put it. And so Lord Justice Simon Brown says that the judge below pointed out the critical expression there is unambiguous impropriety. Do any of the transcripts before us disclose such unambiguous impropriety? And then he turns to an analysis of the tapes. And if we go to page 7, middle of the page, it says, I turn therefore to the last tape, that on which most of the argument before us is centred, which has caused him greater pause for thought. And what had happened was that there had been an agreement, and the question was whether the agreement had been altered after it had been signed, and whether that alteration was one which had been admitted in the without prejudice conversations, and if so, whether that would be unambiguous impropriety.
You mean altered improperly?
Improperly, yes, forgery. Right. Quite. So signed sometime in the past and then subsequently altered by the plaintiff. That was the allegation that the defendant said had been admitted to by the plaintiff in the third of those conversations. And one can see the nature of the arguments from the last 5 lines of the paragraph. In addition, Dr. Nickbin, who wanted to admit the evidence, draws our attention to a particular passage in the discussion at page 5, answers the question, but how is it possible to change it? The plaintiff answers, you threatened and he changed it, referring to another person, and that suggests the first defendant must inevitably be referable to a threat made not at the meeting itself, that's to say not at an original meeting back in 1990, but which could hardly, or rather the settlement meeting, which could hardly have caused the agreement to be altered as it was, but rather to one made on some later occasion. And the critical passage is then this. Lord Justice Simon Brown says he readily sees the force of these points, but it's one thing to suggest, as I, for my part, would be prepared to recognise, that that is certainly the one possible interpretation of the tape, one inference well capable of being drawn from the actual words exchanged. Indeed, particularly if one looks at this through Dr. Nickbin's eyes, it might even be thought the more probable explanation of the plaintiff's comments. It is quite another thing to contend that this is the unambiguous conclusion to be drawn from this conversation. That contention I certainly cannot accept, and then he goes on to explain why. And what this shows in my submission is that this court was applying the criterion of unambiguity to the factual assessment. In other words, what was actually being said, what was the meaning of the words that had been used at the settlement meeting, which is a question of fact. And Lord Justice Simon Brown's approach was to say, well, it's not clear-cut, although the defendant's interpretation was certainly, as he put it, one possible interpretation. It might even be the more probable. It's not unambiguous. It's not absolutely clear, in other words, that that is the correct interpretation of the words spoken. And that being so, he therefore held that the evidence was not admissible.
So this is the case, is it, where what was being alleged was unambiguously improper? It's improper to forge a document, but it failed on the evidential point.
There's a further refinement which we're not directly concerned with, which is whether admissions of prior misconduct going to the facts of the merits of the underlying dispute are or are not themselves capable of being unambiguous impropriety, even if they're proven, which was then dealt with in the later case of Savings and Finken, which I think my lord indicated the court had pre-read, and that raises a slightly different point which we would touch on, because there's a special, as it were, refinement of, or special considerations apply according to this court in Savings against Finken when one is considering the question of admissions about the underlying facts.
But I'm just trying to see what the point was in this case. So there's no doubt about what words were said because they were taped and transcribed, presumably. There was no doubt that if there was an admission of forging a document, that was unambiguously improper. But the question was whether the words said amounted to that admission.
Yes, quite. It was intermediate. My lord's absolutely right. The court proceeded on the basis that if the words meant what the defendant said they meant, then that would be unambiguously improper. Equally, there was no doubt as to what the words were, just as a matter of the syllables spoken, and the question was what they actually meant in the context of a long conversation. And that, in my submission, is a question, obviously, of fact. What do the words mean? And the court applied the unambiguity criterion to it. The next case I wanted to take you to was another one which I gather you pre-read, so Berry and Musavi, tab 1 of the authorities bundle. So, as you would have seen, that was a preliminary ruling on the admissibility of without prejudice evidence in a pending reverse summary judgment application that the claimant, Berry Trade, was bringing in relation to a counterclaim brought by the seventh defendant, who was a Mr. Gadimi. And the seventh defendant said that he had become entitled to a fee of $9 per tonne on shipments of oil through Iran. And that was a case like the present, in which there had been lengthy without prejudice negotiations. There hadn't been a recording, but there was witness statement evidence extracting what had allegedly been said, or indeed allegedly not said, in order to put forward a contention of unambiguous impropriety, which consisted, it was said, of Mr. Gadimi, the defendant, not putting forward in these long negotiations his case, his story, that there had been a $9 agreement. And there is a helpful summary, which I won't take you to in the interest of time, the facts. In the Finken case, which came a little later that year, Lord Justice Ricks did the legwork for us, and at paragraph 50 of his judgment in Savings and Finken, which is tab 12 of the core bundle, one finds a short summary of the case.
Sorry, paragraph?
50.
50.
If your lordships could go in the transcript to paragraph 26, which is about 6 pages in, I think, one sees the approach that was taken by the first instance judge in that case, Mr. Justice David Steele. On the issue of admissibility, he noted that the issue of admissibility was being determined at an interlocutory stage. He observed that it would be inappropriate to seek to resolve factual disputes at this stage, and said that by its very nature, the issue could not properly be determined by the trial judge. In other words, it would be too late, because the issue, the evidence would then have been admitted. He recognised that the very need to call witnesses in order to determine differences of recollection as to what was said during the negotiations would undermine the existence of a clear case, and we say that was correct. He said it was for the applicant to make good a sufficiently clear case of abuse, and that the standard of proof might vary according to the purposes for which the veil over the negotiations needed to be lifted. He directed himself in his paragraph 24, the standard of proof must be such as to establish a serious and substantial risk of perjury which only the content of the negotiations would readily reveal. So that, in my submission, that which was overturned by this court, is a direction which seems very similar in its underlying content to the approach that Mr. Justice Jacobs applied here. A good arguable case, serious and substantial risk, in similar ways, I submit, of saying the same thing. If one then goes forward to paragraph 28, one sees the challenge to that by Mr. Zaccaroli, as he was. He, for the defendant, he challenged the correctness of the test formulated by the judge, which he submits was inconsistent with authority. He further submits that even if that test were correct in law, the judge failed properly to apply that test to the facts of the case, having regard to the existence of a substantial dispute as to whether the statements relied on by the claimants were in fact made by Mr. Gadimi. And then he went on to say that an inconsistency is not an impropriety that would justify the lifting of the privilege in any event. If one could go forward to about 5 to 6 pages, please, to paragraph 48, under the supplement conclusions, 2/3 of the way down the page, Lord Justice Peter Gibson, giving the judgment, said, start with the self-direction that the court, when considering whether statements made and without prejudice discussion may be admitted in evidence, applies the test of whether there is a serious and substantial risk of perjury. Mr. Marshall, who was for the claimant, didn't suggest that that had been applied before. We can see nothing in the authorities to support it. On the contrary, it seems to us to weaken significantly the requirement of unambiguous impropriety and of the need for a very clear case of abuse of a privileged occasion. Although the judge in the final paragraph of his judgment says he bears in mind the need to restrict applications to admit without prejudice statements of the clearest cases of abuse, he then applies the test of a serious and substantial risk of perjury. In our judgment, that is too low a test, and one which would seriously erode the without prejudice rule. The judge should have looked for nothing less than unambiguous impropriety. Now I say, a test of whether there is a good arguable case of unambiguous impropriety is by definition less than a test of whether there is unambiguous impropriety. And the test which Mr. Justice David Steele formulated is, in my submission, difficult to distinguish from the one which Mr. Justice Jacobs applied here. And then if one goes forward to paragraph 51 to see the way in which the court disposed of it, in fact I can pick it up in 6 lines down from the top of the page in paragraph 50, the sentence, this beginning, what has to appear very clearly from the evidence is that Mr. Gadimi was guilty of perjury. And then if we go, 51 deals with the judge's point that, as the judge had held, the position unambiguously adopted by Mr. Gadimi throughout was that the only agreed fee as regards tonnage delivered was $2 a tonne. And then there's a recitation of the evidence, so I can pick it up 3 lines from the foot of the page. We are wholly unable to agree with the judge that it is unambiguously clear that Mr. Gadimi throughout asserted an agreed commission of only $2 per tonne. Again, in my submission, that shows the court consistently, of course, with the test which they had just stated in paragraph 48, applying to the facts this threshold criterion of what is unambiguous. Finally, I noted paragraph 54, the court reserved one particular issue, which, as it happens, goes to my Lord Justice Mayall's point a few minutes ago. We reached that conclusion without taking account of the denial by Mr. Gadimi that he ever made a statement that his agreement with Mr. Musavi was for a fee of $2 per tonne and nothing more. It is therefore unnecessary for us to decide whether the fact of that denial is itself destructive of the claimant's submission of unambiguous impropriety, as Mr. Zaccaroli submitted. So, although the question wasn't decided, namely, is the mere fact of a denial something which is inconsistent with unambiguity, it's nonetheless an issue which arises in the context of applying the criterion of unambiguity to the factual.
But in the previous paragraph, Lord Justice Peter Gibson did point out these were not discussions at which, through tape recording or a detailed note, what was said could not be doubted. And if the without prejudice rule can be breached in this case, we don't see why it can't be breached in any case where an admission, etc., is alleged to have been made.
Yes, that's right. So, of course, where you have words used which are written down and completely clear, then the only question is how improper are they? And that was, to take an example, the case that my lady decided at first instance, Firster and Firster. I don't know if the court's got the rest of the court that read it, where through a mediator, a rather remarkable proposition was said, which my lady held amounted to blackmail. We've discovered some offshore accounts. If you don't settle in 48 hours for more than we asked before, we're going to apply for contempt of court and there'll be all sorts of publicity. Perhaps not totally surprisingly, that was held to be equivalent to, well, my lady said in terms, it was blackmail, and this court agreed. So in those cases, of course, then the factual issue falls away. But in other cases, of which Berry Trade was one and which this is another, that's absolutely not the case, because all you have is unscripted, unrecorded meetings and differing accounts from the participants as to what was said.
So is there a general proposition that you draw from paragraph 53 about the evidential threshold?
The general proposition I draw from paragraphs 48, 50 and 51, which is that the evidential threshold is that the court must be satisfied that the evidence clearly demonstrates the relevant misconduct.
It must be unambiguous.
I beg your pardon?
It must be unambiguous.
It must be unambiguously disclosed, indeed. And that criterion applies as much to the factual assessment as it does to the evaluative assessment of how bad the conduct was.
So it must be unambiguous in three respects, is this it? As to what was said, as to what was meant by what is said, and as to whether that was improper.
Yes, I mean, I would, being pedantic, I would say the first two are sort of sub 1A and 1B, as it were.
Well, I was thinking that you may have a dispute, as I think you do here, as to what was actually said.
Yes.
And then in other cases you may not, because it's written down or it's taped.
Yes.
But I think there is also a dispute here about what was meant, wasn't it? As to whether what was being alleged was to do one
yes,
thing,
there are disputes
to
of
do
both.
one thing or the other.
There are disputes of both the first and second kind here.
Yes.
And
we'll call them 1A and B if you like.
Well, I'm sorry, I'm being a nerd. I apologise. The position is that at every stage of the assessment, whatever fine tuning one can make of the different component parts of it, the criterion of unambiguity applies, and there is a reason for that, which is that then keeps a balance between the virtues of the without prejudice rule and not giving people complete carte blanche to abuse it. And that is why the test is framed in the narrow way that it was. Could I go quickly, please, to tab 11, which is savings against Finken? And that then, so that followed, as I said, the Berry case, and Lord Justice Ricks said Berry was helpful. The situation in savings was that the defendant had entered into a settlement agreement. It was, in fact, I think, the third of his settlement agreements with the bank, and the bank then later sought to avoid even that third agreement on the basis that Mr. Finken had misrepresented his assets and had failed to disclose some shares which he beneficially owned. And there was an attempt by the bank to introduce evidence about a without prejudice meeting at which Mr. Finken was said to have admitted making a false affidavit of means without mentioning those shares. So that was the way in which the issue arose. It was on an amendment application that the issue came up. If you could go, please, to the law report at page 683, paragraph 54. Lord Justice Rick said this: "It also follows from the absence of evidence in this case," that's to say what he's referred to just above it, which is evidence from the other party, not the one seeking to adduce the evidence, that Mr. Tregear, who appeared for Mr. Finken, has not been in a position to challenge the judge's finding that the admission about the shares was unambiguous. And then there's reference to what is to the detail of the evidence, and just between letters E and F, Lord Justice Ritz continued, "In the circumstances, it's probably correct to regard the admitted ownership of the shares as unambiguous because unchallenged." So again, I submit the test of unambiguity is applied to the assessment of the facts. In that case, the primary facts, it seems, of what statements were made at the meeting. The conclusion, I submit, is therefore this, that there is no support at all in the authorities, subject to Dora and Simper, for the admission of evidence in a state where the court is completely uncertain as to whether or not the relevant words were spoken or what they meant. Before we leave Savings and Finken, in the interest of time, it may be helpful for your lordships and my lady just to note paragraph 57 between F and G, which goes to the point about, not directly in point here, but about the significance of admissions in a without prejudice meeting that part of your case is wrong or untrue. Lord Justice Rick says that to tell the truth is not an abuse of the privilege, even if it's contrary to your case. So that, as he says, that's what you're supposed to do, is speak frankly. And then he concludes the public interest in that rule, the without prejudice exclusionary rule, is very great and not to be sacrificed, save in truly exceptional and needy circumstances. So there's a particular feature about the concept of abuse of privilege which underlines the unambiguous impropriety exception, which means that it doesn't apply, at least in a straightforward way, to somebody who goes to a WP meeting and says, yes, I know I've pleaded this, but that's just not true, I admit it. That's, as Lord Justice Rick has held, that's not an abuse of the privileged occasion. Obviously you have done something wrong, but Savings and Finken stands for the proposition that that particular disclosure of past impropriety is not itself something that brings the case within an exception to the rule. That's not what this case is said to be about, but the court obviously needs to see the context. Could I then go to the next heading of my submissions, which is the
Policy.
Policy. Thank you very much. So perhaps if we could briefly go back to the last page of the Nickbin report, Falazid Alizadeh and Nickbin at tab 4 of the core bundle of authorities, where in the final paragraph, fourth paragraph, Lord Justice Simon Brown said, there are, in my judgment, powerful policy reasons for admitting in evidence as exceptions to the without prejudice rule only the very clearest of cases. Unless this highly beneficial rule is most scrupulously and jealously protected, it will all too readily become eroded. And then he goes on to say that people who tape record meetings a further form of conduct to be discouraged. Obviously that doesn't apply here. but the policy I submit is very
It
clear.
doesn't apply here, but who took the photograph of the flip chart?
The photograph was taken by Mr. Niwiara. It was exhibited to his affidavit. When I say it was taken by him, I mean it was obviously taken by someone on the Motorola side. But I'm not making a point that that was done surreptitiously, because for all one knows, he just held up the phone in the usual way and took a snap. So it might have been, one imagines that would have been visible to everybody. We haven't sought to suggest that this was some sort of East German style spy camera that took a picture without anyone noticing. But the point I rely on is not the tape recording point, it's the first this 3 sentences of the paragraph.
Well, going back to your 1A and 1B, it's clear that the flip chart was used in some way at the meeting because there's a photograph of it. It is in dispute what was said in relation to the flip chart, and it's in dispute what the words on the flip chart mean.
Yes. Yes. So all that the flip chart tells you is that that was what Mr. Chunuo wrote on the flip chart, which in itself is, we say, not unambiguous, nor did the judge find that it was. I mean, he simply found that the Motorola case was one which had a plausible evidential basis, but it was denied. For example, and without going into the detail, one point that the judge didn't pick up on was that the evidence from the Hytera side was that the concept of retreat was one that had been made by one of the Motorola participants, a Mr. Hacker. So he had produced his own flip chart, in fact, and he had referred to a retreat and had basically said to Hytera, if you have to retreat to China, it's going to wipe out half of your business, but we will carry on regardless, enforcing this judgment, regardless of the cost. In other words, even if it causes greater damage than we recover, seems to be the subtext. So there was plenty of material. That's paragraph 11 of the annex, which your lordships will find at supplemental bundle tab 8, but I don't take you to it in the interest of time. But there was plenty of disputed material, and the judge didn't claim to be resolving that in any way, or to find that on the material he had it was clear, regardless of what my client said, that there was unambiguity. He said, I can sidestep that. I don't have to find evidentially that there was unambiguity. It's enough if there's a good arguable case. And in my submission, that was wrong, both because it differed from the approach taken in the earlier cases that I showed you a few minutes ago, and because the heading I'm on now, the policy reasons, simply doesn't fit with what Lord Justice Simon Brown said, that it's only the very clearest of cases, that is what the unambiguity criterion patrols, is to ensure that only the clearest cases get through, and it doesn't fit with the wise words with respect of Lord Justice Simon Brown, that unless there is a very careful protection of the rule, it will all too easily become eroded, that the rule will gradually become less and less effective at maintaining confidentiality of discussions. And people going into the underlying thought, as no doubt the court appreciates, is that if one goes into a meeting like this, one needs to have a pretty high degree of certainty that the contents are not going to become available in evidence. And once your lawyers tell you, well, actually there's, somebody can come to court and they can put forward their account of the meeting and they can put it in and it can be held against you, even if there's a good arguable case, then that is going to erode litigants' confidence in having this kind of meeting, and that's the very problem.
So are there circumstances in which the factual issue about what was said is going to be decided according to the ordinary civil standard of proof, or does that never get decided because the evidence is never admitted, or is there a trial of preliminary issue at some point to decide whether it should or shouldn't be admitted?
There has never been a case in which the court has had that kind of voir dire type hearing to decide which of two contested oral accounts is correct. And in my submission, the absent a very extreme case where somebody's account of what happened was just manifestly incredible because, e.g., it was inconsistent with all sorts of other things which were documented, then by definition, the test is one that's meant to be applied in a way that doesn't involve that kind of factual inquiry. And as soon as you get into that factual inquiry, the rule is further eroded, and my Lord can readily imagine if I've got to cross-examine Mr. Niyomiara about the meeting, and Mr. Strange were cross-examining Mr. Shunwo about the meeting, one would obviously want to look at not just the key points that were the dispute, but at other things as well. You'd maybe take somebody through other aspects of the meeting to test their recollection and their reliability. So very quickly you would find yourself opening up the whole content of the meeting. It wouldn't be possible to...
And it would have to be before a judge who is not going to be the judge of the final trial, if this was interim.
It would, and indeed one can see that that's what Lord Justice Simon Brown said at the very beginning of this report on page 2, that it was very wise to have the discussion and the decision on admissibility beforehand, as happened in that case, rather than leave it to the trial judge, which is what the Queen's Bench Master had ordered. Yes, it would be an unreasonable burden to place on a trial judge to say, you've got to steep yourself in the detail of a WP meeting, and then, having decided, if you do, that it's not admissible, put it all out of your mind and proceed to decide.
Can I just bring you back for a moment to buried trade?
Yes.
Paragraph 56.
Yes.
Is not Lord Justice Peter Gibson contemplating trial of the issue?
No, in my respect, no? Well, he's referring to that as a concept, but he then goes on to say that we don't suggest that directions for the trial of the issue of whether the alleged statements are made should be given. So he's saying that there shouldn't be such a trial, and he goes on to say two things. First of all, not only is there no unambiguous impropriety on the claimant's evidence, otherwise it doesn't meet the threshold test, which is but then also he goes on to make the point about that I was just trying to make about how you get sucked into a much wider discussion of and evidence on everything else that was said at the meeting, so the whole cat would be out of the bag.
I mean, to some extent, that is what has happened in this case, isn't it? Albeit only on witness statements, because Mr. Miwara zones in on what he says were the improper statements, and then it is your side which seeks to put them in a wider context of the meeting, talking about the way that Motorola was saying we'll chase you to the ends of the earth and so on, and this is where you hold your assets, and so in an attempt to put those statements in context, we now know, if we read the confidential statement, a lot more about the meeting than we did when we read Mr. Niwara's.
Yes, well, absolutely. The responding party is put in a very invidious position by the sort of evidence that Mr. Niwara put forward, because if you say nothing, you may find yourself in the position that Mr. Finken was in the savings case, where because there was no challenge by him to what he'd said, it'd be said, well, at least on a factual side, the evidence is unambiguous. And if you say something, then you are in danger of getting sucked into further disclosure of the contents of the meeting, which you might be very reluctant to put forward. I mean, in this case, we at least have the fact that the trial in the US had already happened, but on the logic of the judge's analysis, this evidence could have been available throughout. And if this wasn't a trial, I mean, obviously I have no idea what the Illinois rules are, but if one assumes hypothetically this were a trial that happening here, then this information could have been put before the trier of fact. And that doesn't seem right. But in my submission, the way round it is to acknowledge what I submit as the true test, that the court looks at the face of the material that's disclosed to it, including anything that the responding party has chose to put in, and it says, taking that, is it unambiguous? Is it absolutely clear what was said and what it meant? And if so, is it clear that it was sufficiently improper? And if you don't,
you said the trial had happened, but it hadn't at the time of the meeting.
which
The trial in Illinois had not happened at the time of the meeting.
no, sorry, it's happened now.
It's happened now.
Yes,
Yes,
exactly.
yeah.
That's my point, my lord. But forgive me if I wasn't clear. I was simply making the point that these meetings, as you rightly say, preceded the trial. And therefore, if we ignore the Illinois,
because one of the strategies, according to Motorola, that your clients put forward was if the judgment went against them, they would appeal. And they seem to be lodging all sorts of post-trial motions in the Illinois court.
yes. Well, I think things have been. There has been some delay caused by
COVID.
etc.
Yeah.
So are those post-trial motions still pending?
Yes.
Yes.
It's, I think it's you can't just quickly get to your 21 days from the recording of the vote. It's got to go through more stages at first instance in terms of details which I don't want to give evidence about, not because I don't understand it, but there's been a general suspension for some period under a federal general order, etc. I mean, we're in a similar boat. But yes, that is my understanding.
So for practical purposes, the position now is still the same as it was before the judge?
Yes. The policy I'd already taken you therefore to Nick Bin. Very while we're on it, paragraph 36. That passage in Nick Bin is picked up again by this court, stating the narrowness of this exception has often been emphasised, and reiteration of what was said in Unilever, clearest cases of abuse. And then I took you earlier to what was said in Thinking, but perhaps we can very quickly remind ourselves, tab 11, page 684 of the report, paragraph 57. At the very end of that paragraph between F and G, last two lines, public interest in that rule is very great, not to be sacrificed save in truly exceptional and needy circumstances. And then perhaps we could go forward in the bundle to tab 13, which is the Unilever. Very familiar case, I'm sure, to the court, often cited. The general analysis of the rule 2443 beginning at letter H. Lord Justice Robert Walker had no doubt that busy practitioners are acting prudently in making the general working assumption that the rule, if not sacred, has a wide and compelling effect. Says that's particularly true where the without prejudice communications in question consist not of letters or other written documents, but of wide-ranging unscripted discussions during a meeting which may have lasted several hours. I should say, of course, that Dora and Simper preceded this. Dora and Simper was 1999, this is 2000. At a meeting of that sort, the discussions between the parties' representatives may contain a mixture of admissions and half-admissions against a party's interests, more or less confident assertions of a party's case, offers, counter-offers, and statements which might be characterised as threats or as thinking aloud about future plans and possibilities. Then, as Lord Justice Simon Brown put in argument, a threat of infringement proceedings, which is what that case was about, may be deeply embedded in negotiations for a compromise solution. Partial disclosure of the minutes of such a meeting may be, as Lord Justice Leggett said in Muller, a concept as implausible as the curate's egg, which was good in parts. And then Lord Justice Robert Walker went on to set out the main instances of the exceptions. And he went on to say, in a passage which has often been cited at 2448, letter H, after referring to various well-known authorities, says, whatever difficulties there are in a complete reconciliation of those cases, they make clear that the without prejudice rule is founded partly in public policy and partly in the agreement of the parties. They show that the protection of admissions against interest is the most important practical effect of the rule, but to dissect out identifiable admissions and withhold protection from the rest of without prejudice communications except for a special reason would not only create huge practical difficulties but would be contrary to the underlying objective of giving protection to the parties, in Lord Griffith's words, to speak freely about all issues in the litigation, both factual and legal, when seeking compromise, and for the purpose of establishing the base of compromise, admitting certain facts. And in this sentence, parties cannot speak freely at a without prejudice meeting if they must constantly monitor every sentence with lawyers or patent agents sitting at their shoulders as minders. And so, in putting it in other less elegant words, for a court to be asked to pick through a meeting in any sort of detail will, by the very nature of the exercise, substantially erode the privilege, and in doing so it will thereby discourage effective settlement meetings generally. And that is why at the foot of the page, last two lines, Lord Justice Robert Walker said this: the expansion of exceptions should not be encouraged, and when an important ingredient of Lord Wolfe's civil justice reforms is to encourage those who are in dispute to engage in frank discussions before they resort to litigation. If I could then quickly take you to the last case under this heading, which is Offalué at tab 10, Supreme Court case Offalué against Bossett. That case was the one where the Supreme Court decided that an acknowledgement of title to land, which had been made in the course of without prejudice negotiations, it had been made by the necessary implication from an offer to purchase the land from the party making the offer, that acknowledgement could not be given in evidence, so there wasn't a further exception to the without prejudice rule relating to acknowledgements under the Limitation Act, section 29. But of importance is what one finds in the judgment of Lord Neuberger, with whom all of their lordships, apart from Lord Scott, who was in the minority, agreed. If I could take you to page 1021 of the report, paragraph 89. He refers to what he calls the invaluable judgment in the Unilever case. And he then cites the passage I've just read out, saying, in my opinion, that makes a point which should always be borne in mind by any judge, considering a contention that a statement made in without prejudice negotiations should be exempted from the rule. Then at paragraph 95 on page 1023, beginning just above that with a citation from Lord Justice Hoffman, it said in a case called Muller, Lord Justice Hoffman was a proponent of a theory that, as he said in the quotation, the public policy aspect of the rule is not concerned with the admissibility of statements which are relevant otherwise than admissions independently of the truth of facts alleged to have been admitted. And in paragraph 95, Lord Neuberger says, it's third line, I'm inclined to think that that is a distinction which is too subtle to apply in practice. I consider that its application would often risk falling foul of the problem identified by Lord Justice Robert Walker that he's just quoted. And then paragraph 98 indicates how the court disposed of the issue before it, and obviously that issue is not this issue, but the general approach taken is, in my submission, interesting. Third line, or fourth line of 98, I entirely agree with Lord Roger, says Lord Neuberger, that it is open to your lordships to create further exceptions to the rule, and in particular the sort of admission identified in an earlier case. However, I also agree with Lord Roger and with the other two members of the court that it would be inappropriate to do so for reasons of legal and practical certainty. To uphold such an exception in this case would run counter to the thrust of the approach of Lord Griffiths in Rush and Tompkins and of Robert Walker in Lord Justice Robert Walker in Unilever, and would severely risk hampering the freedom parties should feel when entering into settlement negotiations. So The Supreme Court acknowledged that there was a, if you like, a policy choice that could be made, and decided not to take it because of the broader policy considerations about protecting the rule. So just to try and draw some threads together on the legal policy issues and their application to this case, we say first of all that this case does involve an expansion of unambiguous impropriety exception. Secondly, and that's contrary to the general approach laid down in Unilever and approved in Offerlua. Secondly, what the respondents have done in their evidence, what Motorola has done, is precisely what has often been warned against, which is to pick through lengthy meetings. And as my Lord Justice Lewison touched on, the opposing party, my clients, will therefore need to go into further details of the meeting, and so it could go on. And thirdly, as I said, looking at the matter overall, the judge's approach erodes privilege even further. If the approach in this case is taken below is correct, then in many cases it's possible to predict that such alleged without prejudice material will be advanced in evidence or sought to be put forward in evidence. Because parties in settlement discussions will often discuss enforcement and prospects of recovery. And a defendant will often, no doubt, make points about the difficulty of recovery. And it's easy to imagine a spectrum of comments about changes that may occur after a judgment, and those comments may move from predictions to plans to what might be called or interpreted as threats, and where any particular set of words spoken may lie may be quite difficult to decide. It's also natural that the parties may well use, in Lord Justice Hoffman's phrase in the Forster case, colourful and exaggerated language. And therefore it is inevitably going to be fertile ground later for making allegations and for the interpretation or misinterpretation of what has been said. And even more basically, parties, I suggest, will be deterred from going into settlement meetings or conducting them in a free and open way if the say-so of the opposing party as to a threat may be used against them to obtain freezing orders without even requiring a court to be satisfied that the threat was probably made. And while one response to that might be rather like an interview of a suspect with the police under pace to ensure that everything is recorded, that is undoubtedly that would be very detrimental and would in itself discourage frank and open conversation at meetings. And I can respectfully submit the conclusion, therefore, is that the overall response in terms of policy and on the authorities is to protect the without prejudice privilege in to use the words in the Nickman case, a scrupulous and jealous way. Fourth heading is that it was wrong in principle to make a provisional finding. We discovered shortly before the hearing a Supreme Court decision that I sent through by email yesterday, and I've got hard copies if the court needs it, which is not about without prejudice, but it's the Chagan case that was decided in August.
Just pause a moment. I mean, do you say the judge made a provisional finding?
No.
So this point doesn't arise, does it?
Sorry.
I thought because you started off by saying the judge didn't make any finding at all.
Well, forgive me, I misspoke. The judge did make by provisional finding, what I mean is that the judge found there was a good arguable case.
Yes.
That's what I'm calling a provisional finding.
Oh, I see.
So it's as it were, a sort of not finding that anything's been made out even to a prima facie standard, but simply that it surmounts some threshold of arguability. And I call that a provisional finding because...
Right, perhaps I'm misunderstanding.
No, it's probably my fault for
what
going...
you. Just going back to what I seem to remember being taught, isn't a prima facie case a case which you look at without regard to the other side's evidence? Isn't that a prima facie case?
Well, in some contexts it is, but
It's not what you mean by
no,
that.
it's not what I mean. What I mean by a prima facie case is that a court must decide that the particular proposition is more likely than not to succeed.
So doing the best I can on the material I've got, I
Yes.
think X is more likely than Y.
Does the applicant get over 50%? If you're asking it at that stage. So I appreciate it. Right, okay, but I don't have it.
I mean, the unusual feature of this was that it was an on-notice application for a freezing order, which meant that there was evidence from all clients, but also meant, presumably, that there was no duty of full and frank disclosure on the applicant's side. What the content of that duty of full and frank disclosure would be if this kind of application was made without notice is rather difficult to see how in practice that would play out.
It is, and it would put everybody concerned, and obviously most of all the absent defendant, in a very difficult position where somebody is relying on material which is without prejudice, and so the default position is excluded, and is coming to court without the other side being there, saying, you've got to look at this, and yes, it might be said that Mr. X didn't mean this, but here's what we say.
But they might then have to say, we must say, because of our duty of full and frank disclosure, that in a different part of the meeting, they said this, or we said that.
Yes, they would. They'd have to go through the meeting as best they could and ask themselves, what are the other side likely to say if we were in an inter partes setting? Absolutely. So it would be quite problematic. And again, just looking at it in policy terms, if a solicitor is advising a client who says, should we have a settlement meeting? The other side have proposed a without prejudice meeting. Solicitor would have to say, well, in a hotly contested commercial case, the solicitor would have to say, well, yes, but just be aware that things you say can be, or things that it'll be said you've said, can be put forward before a court in some circumstances. It's not, including as in this case. And that sort of advice will inevitably be a deterrent. I'm going to ask my lords to look at the Shagang case, and I don't know if you have hard copies or gather there with the usher.
I think it came yesterday, or?
Yes, it came yesterday, so...
I don't have a hard copy with me, I'm afraid.
No, I'm told they're with the court. And I think I can see a stash there. It looks like this.
Yes, that looks like it.
Yes, I think that's it. Is it? That's it.
Yes, please.
No, I've got it.
I have one, thank you, but my lord and my lady don't.
Thank you very much.
Shagang was fortunately a pretty unusual sort of case where evidence in the commercial court about bribery, the alleged bribery in connection with the charter party guarantee, was said to have been procured in China by the torture, and pretty unpleasant torture, of two of the individuals concerned by the PSB, which I think is the Security Bureau in China. And that confession evidence, allegedly elicited by torture, was retracted at one stage by the individuals concerned, but then they ended up pleading guilty in China with a lot of evidence that to do so was the only way to avoid an extremely lengthy sentence. In that situation, it came before Mr. Justice Knowles, and Mr. Justice Knowles said that he was leaving aside the question of the alleged torture. He wasn't satisfied that the alleged bribery had occurred because it didn't make commercial sense. But he also went on to say that although he couldn't reach a positive finding on whether the torture had occurred, he couldn't rule it out. He was worried about it, and his doubts in that regard further reinforced his conclusion that the bribery had not taken place. And the court, this court overturned Mr. Justice Knowles and said that he should have resolved one way or the other the issue of torture, and if he'd resolved it in favour, but by saying that it hadn't occurred, then he should not have paid any further attention to the possibility that it might have done. The Supreme Court overturned this court and restored Mr. Justice Knowles's judgment. The relevant part of the decision is at page 26, paragraph 92, citation from a House of Lords case in family proceedings called Re B. Lord Hoffman said, the first quote on the page, if a legal rule requires a fact to be proved, a fact in issue, a judge or jury must decide whether or not it happened. There's no room for a finding that it might have happened. The law operates a binary system in which the only values are 0 and 1. The fact either happened or it did not. And if there's doubt, then the doubt's resolved by a rule that one or other party carries the burden of proof. If I could ask you to go forward to page 29 and paragraph 100 under the subheading preliminary facts. In the present case, the allegations of torture were relevant in two different ways. One was in assessing the likelihood or otherwise that the confessions were reliable, and hence whether it was proved as a fact that the bribe had been paid. The other was in order to determine whether the confession evidence was admissible. Whilst the core purpose for which evidence is admissible in legal proceedings is of proving or disproving facts in issue at a trial, it's also often necessary for a court to decide factual questions for the purpose of procedural and evidential rules, and facts which must be proved for such purposes have been called preliminary facts. Paragraph 101, the distinction between finding preliminary facts and finding facts in issue is embodied in criminal proceedings by the division of responsibilities between judge and jury, although in civil proceedings both functions may be performed by the same person. The distinction is conceptually no less important. Examples, preliminary facts, civil proceedings are the fact that a communication between the lawyer and client was made in confidence for the purpose of giving or receiving legal advice to decide if it's protected by legal professional privilege, the fact that a person is capable of understanding the nature of an oath and of giving rational testimony, is he competent to testify, and facts which it is necessary to determine for the purpose of deciding whether evidence is admissible. And then if you could go back please to page 27, paragraph 96. It's of course true that, as Lord Hoffman observed in the B case, if a legal rule requires a fact to be proved, the law operates a binary system. So where it is necessary to prove a fact for the purpose of a rule governing the admissibility of evidence, there are only two possibilities. Either the evidence is admissible or it is not, which depends on whether the fact has been proved or not. There is no room for a finding that the fact might have happened. So that at least is the default position. Obviously that was the case after trial. But if one applies that as a general principle, then obviously it's inconsistent with what Mr. Justice Jacobs did, which was in effect a finding that the fact might have happened. As the Supreme Court observed, there are facts, which are preliminary facts, which it is necessary to determine at the end of 101 for the purpose of deciding whether evidence is admissible at all. And the without prejudice rule in my submission is not dependent on the stage of procedure reached. It applies to any contested hearing. In the words of the Supreme Court in the Ocean Bulk case, paragraph 24, it applies if a contested hearing ensues. That's the rule, and if in the normal way, if one shows that evidence sought to be adduced has in fact come from a without prejudice discussion, then at any stage of the litigation that evidence is inadmissible, and in order to make it admissible you need to prove the fact which justifies or brings it within the exception.
So applied to this case, you say that the effect of paragraph 96 is that there is a rule governing the admissibility of evidence of without prejudice negotiations. That legal rule says you can't admit the evidence unless it demonstrates unambiguous impropriety. Therefore, you must prove unambiguous impropriety according to the ordinary civil standard of proof.
Yes. Right. You must have a 1 rather than a 0 in Lord Hoffman's analogy.
That's going rather further, isn't it, than what I thought you submitted at the outset, which is that on the material available, you have to conclude that the relevant words had been spoken, which is a test which takes account of the interim nature of the proceedings. If you're applying the civil standard of proof, balance of probabilities, that would seem to imply needing to have a mini trial on the point.
Well, I don't accept that it would imply that you have to have a mini trial, because the nature of the criterion that you're applying is one which doesn't require a mini trial and which requires the court to decide whether the material is unambiguous. And so by applying that criterion of unambiguity, the court is supposed to avoid getting into what would otherwise be a mini trial. And the
Well,
point I'm seeking...
on the facts of this case, can the court make that determination on the civil standard without, for example, cross-examination of the witnesses?
Well, then, if it has to get into that exercise, then of course the material, by definition, is not unambiguous. If you've got disputes that need to be resolved.
It might be once you've had the cross-examination, it might be obvious that one side is telling the truth and the other is telling lies.
But that would defeat the way in which the exception is framed. It's obviously not what the judge did here. So it's not the way in which he proceeded. He said, I'm not going to resolve any factual issues. I'm just going to deal with it as a good arguable case.
So do you say that this little part of the judgment in what's called Shagang has resolved the point that was left open in Berry, namely that the denial something was said is destructive of the exception, unless presumably you are satisfied that the denial is utterly incredible?
I'm not sure it's dealing with whether the denial itself resolves it. What this indicates is that there does need to be, at least there needs to be a conclusion reached on the issue, and not simply as a good arguable case, what I've called a merely provisional assessment, or what the Supreme Court says, a finding that something might have happened. But that's not good enough.
Don't you then seem to be attributing different weight to different kinds of evidence in a way which we don't usually do? Because I think the logic of your argument is that even if there is a sworn affidavit by a solicitor who was present at the meeting saying I was there and this was what was said, that is not to be treated as unambiguous evidence if it's challenged. So we do get to the point that my Lord Justice Lewison made. Well, does it become unambiguous if it's not challenged, which raises problems in a without notice application? Is a bare denial enough to make it ambiguous, or are you saying that something can only be unambiguous if there is some physical evidence of it?
As I said earlier, as long as there is a dispute which is credible, then the material can't be said to be unambiguous. And the fact that it might, after cross-examination, be resolved by the judge deciding that he or she plainly believed one side rather than the other, doesn't mean that the material with which the court is presented at the admissibility stage is unambiguous. That is precisely its ambiguity. And if I could just try and develop my submissions in this way.
In effect, you're saying that it's enough for the defendant to raise a good arguable defence.
In effect, yes, because then it's not a clear-cut case, and that's what this exception is about. It's clear-cut cases, what you don't have though is the admission of without prejudice evidence simply by saying there is a good arguable case and there are issues. That's what this judge decided. He didn't say I'm going to do a mini trial. In the case where somebody seeks to apply without notice, that the court simply has no way whether the evidence is unambiguous, so it can't again find that the threshold has been passed. If you're in an inter partes situation and allegations are made about what was said and they're not responded to, then the material may become unambiguous simply because it's not disputed.
Lord Justice Ricks was a bit sceptical about that, wasn't he? Lord Justice Ricks was a bit sceptical about that because he was saying, well, why should Mr. Finken explain if this is all protected by without prejudice?
Well, he said you've got to be careful, but he did, as I read it, and that again may be a problem, but all I'm saying is, as I thought Lord Justice Ricks had accepted, was that at least in that case, the material could be said to be unambiguous because it hadn't been challenged. So although he was conscious of the difficulties, that's where he came out at the end. The reality is that in all but the Dora case, where the court also, with respect, ducked the issue and left it to be resolved later, the only cases where this unambiguous impropriety exception has been applied are ones where there's been something in writing or a tape recording. And that is entirely unsurprising on my analysis, because only there will you get the lack of ambiguity. If I could just go to a bit of Berry that we haven't looked at very briefly in tab 1, paragraph 29. Which records some respondent's notice submissions made by the claimant there, by Mr. Marshall on behalf of the claimant. Further, by respondent's notice, Mr. Marshall seeks to argue the decision be upheld on further grounds. He submits that evidence regarding what was said during the without prejudice discussions could be adduced, even where it was contested by Mr. Gadimi, if such evidence was prima facie true and, if proved, would show perjury, dishonesty or other unambiguous impropriety on Mr. Gadimi's part. He also argues that the question whether or not the statements were made could thereafter properly be determined by a judge at a suitable preliminary hearing or at trial as considered appropriate in accordance with the court's case management powers. And it's that submission that's then responded to in the last last part of the judgment. So paragraph 54 at the end, Lord Justice Peter Gibson had some comments on the submission by Mr. Marshall that a dispute of fact does not affect the question of admissibility, which can be resolved later. The judge, having stated that it wouldn't be appropriate to resolve factual disputes at that interlocutory stage, and that the very need to call witnesses to determine differences of recollection as to what was said during negotiations would undermine the existence of a clear case, nevertheless proceeded to find the disputed evidence admissible. The judge doesn't explain how he envisages the matter would then proceed, and then reference to the fact that it's a summary judgment application, a particular problem. 56 over the page, the judge gave no directions for the trial of the factual dispute. Had he done so, that trial of that dispute should surely have been the occasion to rule on admissibility, but we wouldn't suggest that in a case like the present, directions for the trial of the issue, etc., should be given for the two reasons that then followed. Not only is there no unambiguous impropriety on the claimant's evidence, but at such a trial it would be inevitable that more evidence would have to be given. So in my submission, what one can get from that is that the evidence has to be admissible on what I call a threshold basis, looking at the face of the material that the court is presented with. So whatever is alleged by the party seeking to adduce it, and then any response that the other party has chosen to put in. And assessing that material as it stands is the task of the court, and the court must ask itself, is that material clearly disclosed what the party wishing to adduce the evidence says it discloses. If your lordships could go, and my lady could go to tab 8 of the core bundle, core authorities bundle, which is the Kuwait Airways case. Part of a very long-running saga that I'm sure the court's familiar with. So after the first Iraq war, the Iraqi government and Iraqi Airways took over some planes that had belonged to Kuwait Airways, and the question was whether that was a conversion. At the original trial in the 1990s, it was held that state immunity applied because of the interrelationship between Iraqi Airways and the Iraqi governing authorities. And it then emerged and was eventually proven in a trial called Perjury 1 that that had been the result of a massive systematic campaign of lying by the Iraqis through the English trial process. So they had deceived the original trial judge as to the nature of the relationship between Iraqi Air and the Iraqi government. The context in which this decision arose in 2005 was a yet further trial which was pending in an interlocutory application to obtain documents relating to the communications between Iraqi Airways and their solicitors at the earlier stage. That application was granted by the judge and upheld by this court on the basis of what's called the fraud exception to legal professional privilege. So if one goes to page 2746 of the report, in the middle of the page you'll see the question posed in italics. Does the fraud exception apply to litigation privilege as well as legal advice privilege? The answer has to be that it does. And then if we could go forward to page 2748, please. After reference to some earlier authorities, second line, the fraud exception can in principle apply even when litigation has begun, with the result that privilege will not attach to documents.
Sorry, where are you?
I'm sorry, my lord. 36.
36.
Second line.
Yeah.
Fraud exception can in principle apply even when litigation has begun, with the result that privilege will not attach to documents which further the fraud or the criminal purpose. They also show that courts will be cautious about ordering disclosure or inspection of such documents. That caution has two aspects. One, it may be unfair to a defendant to make such an order if all that's shown on the evidence is a prima facie case, which may turn out on full investigation to be incorrect, and two, I needn't take you to. And then 37, second line, if all one has is disputed versions of events, it will be difficult to say that there is even a prima facie case of fraud. This will be particularly so if the disputed version of events is the very same issue that is to be tried in the proceedings. And then 38, in an earlier case called Sharman Church, where there was only prima facie evidence of fraud and the fraud was alleged in relation to the issues that had to be tried, Mr. Justice Hoffman refused to order disclosure. In Dubai Aluminium, where the fraud related to issues we tried on the application, Mr. Justice Ricks thought that before disclosure was ordered there should be a strong prima facie case of criminal or fraudulent conduct. And then at the end of the report, paragraph 42, summary of the position that the fraud exception can apply to litigation privilege as well as to legal advice privilege. Nonetheless, that's the fraud exception, can only be used in cases in which the issue of fraud is one of the issues in the action where there is a strong, I would use the words, very strong prima facie case of fraud. And three, where the issues in the action, a prima facie case of fraud may be enough. Prima facie there being used in the sense of more likely than not. Disputed versions of events make it difficult to say that there is even a prima facie case of fraud, as Lord Justice Longmore points out. And of course there may be a dispute which is just manifestly incredible and for whatever reason the court can is lacking in any substance, but that's not this case. The judge said that there were disputes and he simply wasn't going to resolve them. drawing the threads together, the aim is, in my submission, of the law in this area. It is to protect the confidentiality of without prejudice discussions in a way which promotes the overall objective of encouraging settlement discussions, but without giving a charter for abuse. And the way in which the law has evolved in order to secure those ends is to give the exclusionary rule a broad scope and to have defined exceptions whose boundaries are carefully guarded. And the restrictive nature and limited impact of those exceptions is, in my submission, ensured by making them applicable as threshold criteria. For the most part, the exceptions apply because of the purpose for which the without prejudice evidence is sought to be adduced. And the typical example is proof of any compromise agreement that's actually emerged from the discussions, where of course you have to be able to refer to the discussions in order to, or the resulting exchange of letters in order to prove the compromise of the action. And so typically in that class of exception, what is being done is not to prove the truth of any statements made at the meeting as statements, but to rather to rely on what has been said as legally operative in itself. And if that is the purpose for which one wants to adduce evidence, then that will be permitted, proof of any compromise agreement being one example. Another example, also mentioned by Lord Justice Robert Walker in his well-known list of exceptions, would be referring to the fact of negotiations as a reason for delay in the conduct of proceedings, which is quite often put forward, I suppose. And another example is if you needed to show that somebody was present in a particular place on a particular day, you could refer to the negotiations. Or another example given in the Russian Tompkins case, an old case in the 18th century, where a handwriting expert was called to look at a letter that had been produced in discussions in order to show that it was the parties. So in those cases, the purpose for which you seek the evidence is one that is acceptable, and that purpose can of course be assessed on a threshold basis by the court, considering whether or not to admit the evidence. It will be apparent from the face of the application and the reason why the party concerned wants to put it forward. The impropriety exception is a little different, because there the purpose is to adduce statements allegedly made for their content. So to that extent, it's different from the other exceptions, and it also has the potential directly to undermine the without prejudice rule. And the law, in my submission, has ensured that this exception is narrowly confined and doesn't risk excessively eroding the without prejudice rule by imposing a further threshold criterion, which is the unambiguity criterion. Does it unambiguously disclose the impropriety concerned? And that test requires the material with which the court is presented to be clear-cut on its face. And so in the state in which the court considers it, together with any response from the other party, but without the need for further inquiry, the court must be able to say, does it disclose without real doubt behaviour which is an abuse? And if the court can't say that, because there is any sort of credible challenge, to what the adducing party has put forward, then there are only two approaches logically that one could take. One would be to have a mini trial, but that would involve eroding the rule. And the other is to say, what I submit the law does require one to say, which is this material is not unambiguous. And to have to go forward into further inquiry, whether actually by some of a kind which appears has never happened, or notionally, as in this case, where the judge says, well, there's a good arguable case with a sort of putative but in fact never occurring trial of the issue, is wrong. It's just simply the wrong approach because the court has departed from the threshold or facial assessment of the material before it. That then brings me to the fifth heading, which is Dora against Simper, which the court will find at tab 3 of the Core Authorities bundle. So what happened in Dora, it's worth just noting it. On the 3rd of March 1999, Mr. Justice Park, as one sees in the start of the Lexis transcript, struck out certain evidence because it was inadmissible as referring to without prejudice discussions. This decision was given by this court on the 15th of March 1999, and the reason for the urgency was that there was then a hearing which, as one can see in the middle of page 2, a hearing to strike out the claim and or to discharge the Morava injunction, which had been granted, which was due to be heard on the 22nd of March 1999. So in the 3 weeks between Mr. Justice Park's ruling and the start of that application or motion, this court managed to hear and dispose of and grant the appeal on the admissibility of evidence. But although the Lexis transcript doesn't say whether or not the judgment was extempore, one can assume that it was either extempore or given more or less immediately after the argument, given the timescale. Now, the facts are set out more fully in an authority which is not in the bundle, but which was later reported, which was the decision of Mr. Justice Buckley on that very same motion. And I will give my lords the reference, and I'll make sure that the copies are available, simply because it helps in understanding the factual background. And I'll mention just one or two
Mr. Justice Buckley, you say? Which Mr. Justice Buckley?
Roger Buckley.
In the Chancery Division?
No, QB. Well, I don't know.
Mr. Justice Park would have been sitting in the Chancery.
Yes, he did. And well, it may be that Mr. Justice Roger Buckley was temporarily in the Chancery Division. I can't. It may have been that it was on the Bristol
probably doesn't matter.
Court.
But anyway, it's the same case.
It's the same case. It's undoubtedly the same case. Dora and Simper. It's the reference, just for your note, is 2002 Butterworth's Company Law Cases 561. It's there in the transcript, and that is understandably a little more forthcoming as to the facts than this case. But one of the curiosities of the case is that Mr. Justice Buckley did strike out parts of the claim, and on the basis of a legal analysis. He didn't once refer to the prejudice evidence, and even to say why he wasn't referring to it. So this is the Court of Appeal decision is a trailer without the full movie. But at any rate, what one can see from Mr. Justice Buckley's decision is this, and I'm just going to, if I may, quickly give the court some dates. That on the 10th of February 1998, there was judgment on liability in the first proceedings for Mr. Dora against a company then called PlaySafe, and that was estimated to result in a total bill of approximately £600,000, which PlaySafe couldn't pay. And on the 26th of February 1998, Barclays Bank appointed receivers over the company then called PlaySafe. And over the next few days, an agreement was reached to sell the assets of PlaySafe for £59,250 to the fourth defendant in this case, which was an off-the-shelf company originally called Acroman, which then changed its name to PlaySafe. And the former director and chairman of the original PlaySafe, Mr. Simper and Mr. Stenning, became the top people at the new PlaySafe, although they didn't provide the money, which was brought in by an outside investor. So those were the facts, and on that basis, a Moraver order, as it was then called, was granted by Mr. Justice Robin Jacob in December 1998, and there was then the proceedings that this court was concerned with. And one can see from page 2, third paragraph on the page, that Mr. Dora, who was the successful plaintiff in the first action, sought to recover from the directors of the fourth defendant and the new company, the fourth defendant, and he alleges the sale of assets by Acroman to the fourth defendant. Acroman was in fact the name of the new name, sorry, of the old PlaySafe, and that sale was, that he alleged, was at an undervalue in breach of section 216, and he also claimed damages for conspiracy. And then one can see the sequel in the next paragraph in terms of the procedure that then took place. Lord Justice Aldous, giving the first of the two judgments, says in the second half of the fifth paragraph on the page, we're only concerned with the question of whether Mr. Forsyth's evidence is admissible. That was evidence produced by Mr. Dora. Concerning without prejudice discussions, nothing I've said or will say is intended to reflect on the actions of the parties or their credibility, which are issues for the judge who ultimately hears the motion. And then one sees the evidence that was highlighted by the Court of Appeal in the paragraph at the bottom of the page. Mr. Stenning said that if he, Dora, succeeded in obtaining judgment against them in the first action, they would have no hesitation in transferring the business to a new company so as to render any judgment obtained by him effectively unenforceable. Made very clear Dora should not be in a position to enforce, as the debtor company would by then have no assets. So might be there that it's going to be a transfer for no or no meaningful value, because otherwise, of course, if you sold it at full value, then the debtor company would have assets. And the suggested purpose is, quote, to render any judgment effectively unenforceable. Going over to page 4 of the transcript, one sees the two submissions by Mr. Coney, who is the appellant for acting for Mr. Dora. The first submission, which Lord Justice Aldous dealt with second, was on the basis that the statements were not admissions in the first action, and so they didn't fall within the without prejudice rule. Now that, of course, was a submission which, although upheld, preceded the consideration of the rule by this court in Unilever and then Ofuluwe.
Sorry, can I just ask you about the first complete paragraph on page 3? Lord Justice Aldous says he wants to make it clear that the affidavit evidence of Mr. Simper and Stenning is to the effect that no such statement was made. And then he says, in those circumstances, I proceed upon the basis that the statements were made. But note that it may turn out that Mr. Forsyth will not be believed. Does he explain why he proceeds on that basis?
He doesn't directly. He does say something a little later on which has been considered in subsequent cases, which may bear on it. I can't claim to shed any light on that, except that what it seems to do is to avoid, and this is my submission about the case, that the court avoided any evidential threshold or test whatever. It said, simply going to, rather as you do on a strikeout, I'm going to assume that the party's case is correct, simply for the purpose of dealing with the application before me. And there was no discussion of any evidential threshold at all. It was, the court dealt with it on the basis it was enough that there was an allegation. Coming back to page 4, two submissions. So the first one was that they weren't within the rule at all because they weren't admissions relevant to the first action. That would no longer stand, but may be relevant to the way the court disposed of it. And then halfway down, second, he submitted that the statements were at least capable of being understood as a threat of impropriety, in that it was a threat to put the assets of the company and the directors beyond the reach of the court's judgment by improper means. And followed that the cloak of privilege couldn't exclude the evidence. So the contention was that it was improper means, not just to put the assets beyond the reach, but to do so improperly. And then after citing Forster and Friedland on page 5, third paragraph, in this case we're considering the matter at an early stage, haven't even reached the stage of witness statements, application to strike out and or to set aside Moravian order. In my view, the court should at this stage decide whether the statements would, if proved, form the basis for establishing unambiguous improprieties for the judge who hears the matter to decide whether they do. In my view, when paras 9 and 10 are taken into account together with the evidence of Mr. Simper and Mr. Stenning, it is established that the evidence should be sought to be struck out, should be understood as disclosing unambiguous impropriety. The evidence alleges that these gentlemen would make sure the judgment which might be obtained by Dora wouldn't be satisfied due to the action they would take, resulting in the company's assets being transferred out of reach of the court. So, 2 points. First of all, he appears in my submission to accept the submission of the applicant there, that the appellant, that what was disclosed was putting assets beyond reach by improper means, because it's the improper means which transfer the assets out of reach of the court and then make the judgment unenforceable against the transferor. Secondly, he's approaching it on the basis that the court should simply decide whether, if proved, the statements would establish unambiguous impropriety. He doesn't apply any evidential test to that. He leaves that up to the judge who hears the matter to decide.
The matter being the motion to discharge.
And to strike out. So,
Strike out.
well, as he says in the second line, it's an application to strike out the case because it.
No, but that's to strike out the action.
Yes, yes. So it isn't simply a freezing order case. It's a. If you look at the page 2, sought to strike out the proceedings.
Yes. So he is envisaging that a judge hearing 2 interlocutory applications is going to decide what? Whether Mr. Forsyth should be believed? What is this judge going to do when he hears the motion?
My Lord, I'm constrained in what I can say by convention and protocol. I mean, it is very hard with respect to follow what the learned Lord Justice was saying, but all one can get is that he was making no evidential decision himself. He was applying no evidential threshold, even a good arguable case threshold. He was deferring the decision to the judge hearing the motion. And how that judge was to deal with it is not explained. And that may explain why Mr. Justice Buckley dealt with the matter without referring to it. But that also we don't know. What he doesn't do is say, I'm reaching some assessment of the material and it's admissible because of that assessment. He seems to defer the whole question, as I read it, to the judge. And he also does it on the basis that improper means are being disclosed. And he says in the next paragraph, which has proved controversial in subsequent cases, he also takes into account the affidavits of Stenning and Simper, which state that these statements were never made. They may turn out to be right, but they don't suggest that what's alleged to be said was not improper, or that something like that was said was taken out of context. For that reason, I believe that this case is an exception to that prejudice rule. It isn't easy to understand how somebody denying that something was said could make the case an exception. He then goes on to accept.
These days, we try and discourage witnesses from making submissions about what is improper or not.
Indeed, because it might be thought a matter for submission. As I recall, even there were plenty of people who thought that was the case.
Just go back to the preceding paragraph. If Mr. Justice Jacobs, in this case, had applied the test which Lord Justice Aldous seems to be applying there, he would have asked himself, I must ask myself whether the statements would, if proved, form the basis of establishing unambiguous impropriety. And then I, as the judge hearing the matter, must go on to decide whether they do.
Yes, exactly. And he didn't do either of those things. He didn't. He landed in a completely different zone, which is to say, is there a good arguable case? So Lord Justice Aldous does seem to have contemplated a binary finding by a judge down the line, and that in the meantime the evidence was admissible simply because, if proved, it might establish the relevant impropriety. But it's fair to say, and this is what was later said in Berry, that there's no discussion of the evidential threshold at all. And if one looks at the other member of the court, Lord Justice Ottom, page 7 at the bottom, he says, last 2 and a bit lines, the words allegedly used, given their ordinary and proper meaning, amount to an unequivocal implication that the assets of the company would be placed outside the reach of the court by improper means. And he then says that's improper. He doesn't discuss the evidential threshold at all. All he says is allegedly used. And it doesn't seem to address at all or take account of the factual issue. So again, what one doesn't see with the judge is a good arguable case standard. If we could very quickly, I'm conscious of the time and I may have to ask Mr. Sprange's indulgence, but if paragraph 42 of Berry, tab 1, about 3 pages, 4 pages.
We have read this.
42 says, after referring to Dora and commenting on what Lord Justice Aldous said in 40, 42 says 2 things. First of all, that the case is distinguishable because it didn't involve admissions of fact relevant to the first action. But then in the 5th line, this court did not address the difficulty of how evidence which was disputed could establish unambiguous impropriety, saving the passage of Lord Justice Aldous' judgment where he refers to what the directors didn't say, which quite respectfully doubted, seems to adopt the approach of admitting the disputed evidence on the footing that the judge who heard the second action would decide whether the statements were made, etc. So the analysis in Berry is that this court did not address the difficulty of how evidence which disputed unambiguous impropriety. Of the 2 judges who did consider it, of the only judges, I mean, in Dora, Lord Justice Aldous made a comment about what the directors didn't say, and Lord Justice Ottom didn't touch on it at all. And what one can't establish from that is any sort of ratio as to the proper approach to evidence. Can I now move on as quickly as I may to a separate topic, which is what I call the qualitative test. Namely, assuming that I'm wrong about the threshold and that the judge was correct to say it's enough that there's a good arguable case, we still say that this is not a case of unambiguous impropriety.
What are we assuming here? That your client said what Motorola says they said?
Yes, that it's enough that there's a good arguable case that is what happened.
And therefore, for the purpose of the qualitative assessment, we assume it's true. Do we?
Yes, that's what the judge below, as I read it, did. And I submit that this case is simply not of the same, even making that assumption, in other words, treating the facts as Motorola put it forward, this case is not of the same level of seriousness as previous instances accepted as falling within the doctrine, and it extends them to admit this as an exception would lead to precisely the problems of going into detailed discussions and having to work out where on a spectrum of comments or plans or threats any particular statement was made. The impropriety needs to be absolutely clear cut, as an impropriety, and that the removal of assets in itself is not unlawful, even in this jurisdiction, let alone on a worldwide basis. And of course, this is a conversation between an American multinational and a Chinese multinational. In America, where I think it's fairly well known, freezing orders aren't available at all, as they are not in many other jurisdictions. And we do say that the judge, with respect to him, elided the difference between a case of removal of assets per se and a case where removal of assets is effected by means which are themselves improper. The Dora case, and I won't go back to it, appears to have involved allegations of the latter kind, and there's repeated reference to improper means in both judgments. Just setting the material into a slightly broader context, the cases that have previously come up are all cases of blackmail, or where blackmail has been considered. So, without taking your lordships to it in view of the time, in the Forster case, Lord Justice Hoffman, which introduced the phrase unambiguous impropriety, Lord Justice Hoffman said that the privilege should not be used as, in his words, quote, a cloak for blackmail, unquote. In one of the cases he mentioned Haywick, which is in the bundle, core bundle, tab 7 at page 4, I'll just give you the reference if I may. There was a tape recorded conversation in which, rather obligingly, the party concerned, without prejudicing the conversation, the party concerned said, yes, of course I'm blackmailing you, what would you do if you were me? So it was there out of his own mouth. In another case called Djibouti, Boré and Djibouti, which was decided by Mr. Justice Flo as he was, I'll just give you the reference. It's core bundle tab 2 between pages 619 to 621. A representative of Kroll, acting on behalf of the Republic of Djibouti, said to a Mr. Boré, who was the defendant against whom a freezing order had been obtained, that he would be pursued as a terrorist through international sanctions and other matters unless he agreed to a settlement, which was actually for more than the claim had been framed.
Those are obviously quite extreme cases.
Yes.
But would you accept that to do that which is prevented by a typical freezing order qualifies as impropriety? And if it doesn't, then what's the basis on which freezing orders are made? It must be that they are to restrain conduct which is wrongful in some way, mustn't it?
Well, and to answer those in reverse order, freezing orders are made on the basis that the object or effect of a defendant's conduct creates a risk that the court's potential judgment will be frustrated. So they're not made on the basis that even that somebody is trying to move assets. I don't accept that conduct which, even if it's intended to make judgment harder, is sufficiently improper to come within the unambiguous.
The distinction you're drawing, which I think I understand, is that the distinction between the reasons why freezing orders are made, on the one hand, and, as it were, the superadded factor which you need to broach the without prejudice privilege in order to establish the evidence upon which a freezing order might be made.
Yes, exactly. It's got to be, however one puts it, and it's been put in terms of impropriety, which, assuming the conduct to have been proved, is very clearly improper. So it's got to be something fairly extreme, and that's the way in which the law polices this narrow exception, and ensures that it doesn't start to intrude into the without prejudice rule. And if one looks at all the cases where the exception has been invoked, there is, in my submission, a difference, which it might be difficult to formulate in terms of some absolute bright line rule, but a difference between that sort of conduct and merely moving assets without using improper means to do so. And if we could look at the judge's judgment, there was, in my submission, a real tension in his judgment between the concept of moving assets per se and the concept of doing so by improper means. If you could go to paragraph 54, please, after citing Dora. He says it's authority for the proposition that a move assets so as to deprive a successful claimant of the fruits of a judgment does come within the concept of ambiguous propriety, and in these words, at least if the clear implication of the threat is that this will be accomplished by improper means. So there it's improper means. Paragraph 55, he then refers in the first line to a threat of this nature. It's not clear whether that includes improper means or not. He then draws the analogy with freezing orders. That may then suggest that he had in mind conduct with or without improper means, but other references bring back improper means. If your lordships and my lady would go to the foot of page 103, paragraph 66, last line on the page. In the present case, by contrast, he says the authority of Dora shows that threats in a without prejudice meeting to remove assets by improper means so as to frustrate a judgment would, if made, be regarded as unambiguous impropriety. In 67, he says there's no significant difference between this case and the statements which he thought were held admissible in Dora. At the end of 68, or rather 68, he refers to the submission made by Mr. Rubin based on a decision of Mr. Justice Briggs, not unlawful to move assets in order to try and defeat the claims of creditors. If it's not unlawful, one has to ask why should it be considered unambiguously improper. And then last sentence, the decision in Dora shows that such deliberate conduct would be regarded as unambiguous impropriety, or at least that threats to do so by improper means would fall outside the scope of the protection of the privilege. And then in paragraph 69 he addresses the actual detail, and this relates back to his summary of the evidence at paragraph 38. If I could very quickly go through it, on the sixth line, the third sentence, Mr. Downs submitted, for example, that moving assets around while still being beneficially owned by the same company in order to make enforcement more difficult isn't necessarily improper. The judge held that was not consistent with Dora. But if Dora related, as he had said earlier, to improper means, then the purpose alone cannot make an act improper. In the fifth and sixth sentences...
But the point of surely in Dora was that the assets were no longer owned by the same company.
Were no longer...
Owned by the same company.
No, quite. Exactly.
The judge seems to have misinterpreted the facts of Dora at that point.
Indeed. I mean, the judge was holding a hearing by Zoom on the 7th of April when the evidence had been put together in an enormous rush in the previous 2 weeks. So, but he may not have been taken.
The point in Dora was there was a transfer said to have been at an undervalue.
Yes.
So that the company against whom the judgment was obtained had no assets.
That's right. But if I'm simply moving assets to another jurisdiction where it may be more difficult for somebody to get enforcement, that's not covered by Dora, and in my submission it's not within the concept of unambiguous impropriety. And then the judge goes on to talk about undercapitalisation. He says some aspects of what Mr. Chu is proposing might fall short of constituting improper means. For example, at least viewed in the abstract, the undercapitalisation of a subsidiary might not in itself be improper means. The word undercapitalisation is used in a rather pejorative way by Mr. Niyara of Motorola, because what he says is that he was told that a company had 25 million in cash and it would be reduced to all it needed to operate, which was 5 million. So it would be better to describe it as a reduction in overcapitalisation rather than undercapitalisation. The judge accepts that in any case that's not improper. He then goes on to say, I don't see how it would be proper for there to be a change in the entities to be paid by customers in order to frustrate collection, i.e. by requiring customers to make payment to a Chinese entity rather than the entity in a different jurisdiction that has supplied the goods or service. But with very great respect to the judge, I mean, that happens all the time. Every time you buy something on the internet, you find that you're paying one company rather than a different one than the supplier. And it's perfectly ordinary for a parent company to receive monies which for a supply made by a subsidiary in a different jurisdiction. It just cuts out the middleman and you don't have to have a process of license payments or transfer pricing or returning the dividend. And the idea that that's judge doesn't explain is not a tenable one. But he says in any event, that's not the basis on which he proceeds. Last 4 lines, I consider the statement should be viewed as a whole. So viewed, they amounted to a threat to move assets away from jurisdictions where enforcement could be accomplished without undue difficulty into countries which were murky, and to do so with a view to frustrating enforcement. Well, here we're back just to purpose, and moving assets without using improper means does not involve anything that DORA was concerned with, and it would be an extension of DORA and a new and inappropriate development to find that it met the concept of unambiguous impropriety.
Now, Mr. Bale, we seem to be running out of time for your Chabra point.
We do. So can I ask you for 5 minutes to make it?
Yeah.
Thank you. So, position in relation to Chabra is that everyone accepts, and the judge directed himself, that is an exceptional jurisdiction. What the judge failed to explain is how it is that in this case it was appropriate to make a Chabra finding, the Chabra order. So the Motorola applied only ever for a domestic freezing order, and have been given only a domestic freezing order, and the judge observed that that was probably because they would have had difficulty in making an application in support of foreign proceedings in asking this court to restrain worldwide assets. That point was one which he noted, and I'll give your lordships the reference in a moment. Page 117, paragraph 119. And for that reason also, the judge refused a worldwide disclosure. Paragraph 109 is, page 114 is where we get the reasoning in support of the Chabra order. So higher up on the page, paragraph 105, he correctly directs himself that the jurisdiction is exceptional. And what he says in 109 is that the purpose of the proposed freezing order is to seek to preserve the underlying assets of both Shortway and Sepura. So Shortway is the top UK intermediate parent, and Sepura is effectively the head operating company in the UK with lots of subsidiaries underneath it. But the difficulty with the judge's reasoning is that one can't simply assume that the purpose is to preserve the underlying assets of subsidiary companies, because to do so would be to treat the assets of a subsidiary or a sub-subsidiary as being the assets of the defendant that is itself subject to the freezing order, the so-called cause of action defendant. And that's precisely the point which this court has held is not correct. I won't take you through it, but it's Lakatemia against Sue, which is in tab 28 of the authorities bundle. And Lord Justice Tomlinson said memorably, it's often uncomfortable to be reminded of basic principle. So it can't be taken to be a purpose of a freezing order against a parent company, cause of action defendant, to freeze the underlying assets of a subsidiary. That is the very step which has to be achieved by a separate Chabra order, which is something exceptional. With respect to him, didn't identify anything which was exceptional here. And if he's right, then in any case where there is a freezing order granted to a defendant, whether individual or corporate, which owns companies, then it will be possible to make a Chabra order against those companies themselves. Now, of course, there are lots of cases, the typical, if I can call it this, oligarch case, where a defendant directly or indirectly owns a string of offshore companies, and the court is prepared to infer that all those companies are his nominees. No one's suggesting that's this case, and the judge himself noted at the top of page 112, paragraph 96, there's no evidence to suggest that the subsidiaries here are anything other than normal companies within an international group, a reputable international group, operating properly. So it's not the nominee case, they're proper companies with separate personalities. These issues were explored by, as she then was, Mrs. Justice Gloucester, in a case called the Mahakam, which is, I'll take you to in my final minutes. It's at tab 33, which I believe is in the second supplemental authorities. Page 527 of the law report, paragraph 42. In the course of a review of the principles, which I refer to, which I go through, Mrs. Justice Gloucester said it's not legitimate in the context of third-party freezing.
Sorry, I missed the reference. Where are you?
527 is the page, 42 is the paragraph.
42. Yeah.
It's not legitimate in the context of third-party freezing orders to disregard the separate corporate personalities of individual companies in a group merely because the ultimate or intermediate holding company may have the practical ability to require a subsidiary to act in a particular way, or because it's necessary to achieve justice, even in circumstances where one or more of the companies in question may have been involved in some sort of impropriety. And then going forward to page 537, paragraph 62, she says, nor is there any justification for the short reading is why he submitted it was just and convenient to grant a freezing order over, and then HSPTL is the subsidiary there, assets up to the full amount of the award judgments. The mere fact that HIT, which was the cause of action defendant, was the subsidiary's 100% shareholder didn't justify a freezing order over the subsidiary's assets, even given the evidence suggesting that the Humpers Group as a whole had taken steps to render certain companies in the group judgment proof, or at least to make it more difficult to enforce judgment against such entities. Again, to do so would breach the principles of separate corporate personality. She goes on to say at the end that the fact that the group as a whole had taken steps to render certain companies judgment proof didn't justify an order against any subsidiary in the group. And if that's correct, then it simply can't, the judge's judgment flies in the face of it, because he didn't identify anything to make it proper to breach the, as he put it, or as Lady Justice Gloucester put it, the ordinary principles of separate corporate personality. And one is left, therefore, with the proposition that it's enough that there's a case for a freezing order against a parent, and therefore the underlying assets of the subsidiary can be enforced or protected rather by a chambord against the subsidiary. That's not the law, and if that were to be the law, it would be contrary to the Mahakam, and it would also lead to quite a considerable increase, I suggest, in the general burden of freezing orders in terms of what can be granted and what has to be dealt with. And that's my point on the chambord order, and I'm grateful for the extra time given to us today.
Thank you, Mr. Bauer. I have no further questions.
No, thank you.
Thank you. Well, now, Mr. Sprange, do you want 5 minutes now, or would you rather start again at 5 to 2?
I think I'll ask you that question, my lord.
Well, I don't mind. Up to you.
Well, let's. If I start with 5 minutes now, I might just give you some threshold points.
Yes.
That will be worth considering over the break. The thrust of Malone and Friends' presentation is that the approach taken by the judge and indeed the court in Dora will erode the without prejudice protection. And from the very outset, I want to make clear that is not the position as far as we're concerned. If we look at the public policy that stands behind the privilege, it is to encourage parties to speak freely at without prejudice meetings, so that they don't then go to a trial and have their conversations picked apart with an attempt to prove admissions. What Dora and the judge in this case decided is that if you turn up to a WP meeting and you make a threat that's improper, that may be admissible. Those are two very different things. And if Dora continues as the correct law and the judge is upheld, there will be no erosion of the public policy that stands behind the privilege. And on that, it is worth bearing this in mind, that where you are talking about admissions made at a WP meeting and their use, it's going to be in circumstances where there'll be a trial on the merits, and the admissions, and I will take you to the cases after the break, the admissions go to the merits of that dispute. here we're not talking about anything said as to the merits. It's a separate, distinct threat, and there will never be a merits determination. So in one swoop, we can, in my submission, push aside cases such as Berry and the others that will come to them, because they're simply not analogous and don't help us. And what I say is this: there will be no erosion of the privilege, but if you're a party and you think it's proper to turn up to a without prejudice meeting and make threats that you will make yourself judgment-proof, your lawyer should be telling you that that's improper, you shouldn't say it, and if you do, you run the risk that it will be admissible in a freezing order application at a later point in time. And that, in my respectful submission, wouldn't alter the law as it presently stands, and certainly wouldn't erode the privilege. Unsurprisingly, from that primary submission, I say two things. One, that the majority of the authorities that my learned friend has been through don't help you because they deal with a different factual situation. And I'll take you to some passages. The second point is this: we do not accept that the exception to legal professional privilege, the crime fraud exception, is relevant at all, because the two privileges are totally different. One is between a solicitor and his client, and the public policy.
Yeah, you made that point very eloquently in your skeleton argument that LPP is about stuff you don't know about,
Yes.
whereas WP is about stuff you do know about but can't use.
The cat's out of the bag. It's just what you do with it after that. The other point I'd say this, my lord, on that is when you look at Berry and also Ocean Bulk, the list of exceptions to WP privilege is long. There's 8 of them according to Ocean Bulk. You don't see those type of exceptions with LPP. And the second point is when we're looking at this, we're looking at an abuse. That's the word that is used in all of the authorities, an abuse of the privilege. I can't fathom how, despite being a lawyer and having to put up with clients, you can abuse the legal professional privilege. Indeed, that's part of your job, to hear everything, to have everything described to you as the lawyer receiving it. Where you're talking about an inter partes communication and the question of abuse, well, then we're talking about a very different privilege and a very different approach to exceptions to it. What I intend to do, and I'll probably do this after the break, is go to 6 of the authorities and then address the evidence as to the unambiguous and proprietary, and then the standard. And to do those things, I'd just like to remind the court very briefly of the context of this particular case, because it goes to each of the issues that you need to decide. Perhaps I could just ask you to take up the judgment. It's at tab 4 of the core bundle.
7, I've got it as.
Oh, sorry, 7. Yes, you're correct. And just take up page 91, paragraph 16. This is a case in which Motorola has received a very substantial judgment. And to give you a sense of how substantial, Motorola's assets at common ground are just over $4 billion. And this judgment, including the compensatory and punitive, is over $700 million. So on any view, it is a very substantial judgment in monetary terms. It also includes punitive damages, and it also includes findings, or I will call them implied findings, as to trade secret misappropriation, which is very important when we get to other issues. If we could also take up paragraph 78. This is in the section of the judgments where the judge was reaching his conclusions as to risk of dissipation. And looking at paragraph 78 to 80, this is what the judge has, on a good arguable case standard, concluded with respect to Hytera, that they were complicit in the theft and use of trade secrets. This involved a significant degree of planning. There was an improbability of the Hytera recruits, that's the 3 former Motorola employees, acting of their own volition. Hytera had a motive to proceed in this way because its analog radios were literally going out of fashion and they needed to turn digital. And this is another important point when we come on to the crux issues. In this case, there was an absence of evidence in the Illinois trial from the Hytera recruits, but also Hytera's senior management. And you've seen our criticism of the fact that we still don't see them in this case. It's on information and belief on a critical issue. And then just the last 3 points really go to the Hytera recruits. We say they were effectively gagged by NDAs. They were paid a lot of money, which seems a strange thing to do to people who have apparently stolen trade secrets. And that took place 18 months after the trial on a complaint that I'll come to later.
You call this context.
Yes.
I can see it may be relevant when we get to your respondent's notice, but
Yes.
is it relevant to the without prejudice issue? And if
Yes.
so, perhaps you'll explain why.
Yes, because if you're looking at what was said at a meeting when things like retreat, PRC, Russia, Africa are concerned, and there's a debate about whether that was meant as a threat to make yourself judgment-proof or just a description of commercial activities, the context of that discussion and the parties' dispute is very relevant because it's very plausible if you have stolen trade secrets and you've gone through this elaborate plan that you will say, I'm going to make myself judgment-proof because what I've proceeded to do from the very beginning is to steal from you and avoid having to spend my own money on research and development. And so it's a key plank of the plausibility when we'll come on to later, the judge's consideration of the evidence on the WP meeting and his conclusion that there was a good arguable case that what was said was as per Motorola's description of events. So it's relevant in that sense.
Right, shall we come back to that at 2 o'clock?
We shall.
Court rise.